Welcome to UpStart Live with PayU. I'm Mansa, I'm your host for the evening. Before we start off, very sorry for the delay. We had a few technical difficulties that we needed to solve. Firefighting always when it comes to working from home and virtual. So thank you so much for being patient with us. So PayU, as you all know, is one of the leading payment service providers. We are across sectors like airlines, SMB, and of course the startup community. Upstart is a series that PayU runs. We have been successfully running it for about 5 years now, with close to 2 years virtually. And we have had great success where we have brought in thought leaders like Raddhika herself. She's our speaker for today, where we talk about basics of startups, right, for entrepreneurs, where we talk about any topic that is related to entrepreneurship. So today's session uh, is about legal nuances, where Raddhika, who is the managing partner at Aletheiaa Legal, she is a lawyer by profession, and now she's gone on to becoming a entrepreneur herself as well. She'll be covering topics on legal nuances that comes from idea to funding. So anything that is legally illegal compliances, diligence related, from idea to funding, anything that you would like to know about, today is the time you ask Raddhika for your answers. So, Raddhika, without further delay, over to you. Please introduce yourself first, and then you know the deal already. Another small note: Raddhika has been a speaker with us for multiple sessions before, offline and online as well. So it is always a pleasure to invite you, Raddhika, back, because we feel that you are the one-stop solution for all legal queries that startups might have. That is why we keep inviting you. Thank you so much for doing this for us. Over to you.
Thank you so much, Mansa. And as I say, it's always a pleasure and coming on Upstart and PayU Upstart Code Up series and speaking to startups and entrepreneurs about legal nuances. And I think today is the 14th session that I'm doing for PayU. I think that says it all. And the amount of fun that I have and the exposure and the thing of speaking to people and just answering their questions, I think that's something which I really enjoy a lot. So today's session, the topic is legal nuances from ideation to funding. And as the topic says, what I'm going to try to do, I know we have like 40-45 minutes. I'm going to just go through the main topics that a startup or anybody who's thinking of starting off should keep in mind from a legal perspective. Yes, we can't go into each and every minor detail, but at least the top 10 things that they should keep in mind when they're starting off. So that is my intention. And what I would request is, as the session goes by, you have any questions, just type it in, and I'll be more than happy to answer those questions. So without further ado, I will start sharing. Mansa, let me know if the screen is can be seen. I will just share the
Your screen is up.
It's up. Perfect. So let me just start by a brief introduction. I'm Raddhika Singh. I'm the managing partner of Aletheiaa Legal. I've been practicing for the last 15 and a half years, and I've had the privilege and the opportunity to work with India's leading law firms like Remfry and Sagar, KNS Partners, and Luthra and Luthra. And I have learned a lot there, and I'm really grateful to all the three firms for the knowledge that I have today. And then I started my entrepreneurship journey in August 2014. It has been more than 7.5 years, and it's been a beautiful journey. I love every aspect of it, and every day there is a new learning. So that is how it goes, and I'm really happy about that. And today, let's get started with the legal nuances of from idea to funding. So, when we are starting, or when you're thinking of starting something of your own, the first thought that comes in the mind of an entrepreneur, or you may be working somewhere and you feel like, I really want to start something. So, the first question which comes in your mind is, what is the type of legal entity that I should set up? We know that in mainly there are four types of legal entities in India, which are the most popular. One is a sole proprietorship, one is a partnership firm, a private limited, or private limited company or a limited liability partnership. So when you're thinking of setting up a business, what I generally tell people is that if you're what is your intention, that needs to be in mind. Are you looking at initially just starting off, testing waters and seeing if you want to continue on your entrepreneurship journey or not? You may be like, okay, let me see if this is for me or not, and then I'll take a call. Or you're very clear that I'm taking the plunge and I want to have a startup, and I'm looking at getting funding and seeing how it goes. That is the second thing. Third thing can be that people have been working for a very long time, they have immense capital, they do not need funding, and they're clear that they want to enter into the entrepreneurship journey, and they don't need funding from anyone for at least maybe the next 5 6 years, and they are good with that. So keeping these aspects in mind, you need to look at your business, the type of legal entity that you want to take on. If you're just trying to test waters for a while and you're clear maybe for a year or two and you're not looking at funding immediately, in some businesses you could look at starting off as a sole proprietorship because the compliances there are the minimum. So you can just start, and this generally helps in the services sector where the capital is not that much and what you need are your skill sets. So that could be one sector where you could look at sole proprietorship, or where, like I said, you're just trying to see how it goes for a year or two and then see if you would want to go on. So, from a sole, you can start off as a sole proprietorship or as a partnership firm, depending on if there are two people. Um, but if your intention is you're clear that you want to start the journey and you're looking at getting funded, or within a year or two, you're looking at raising funds, then the right vehicle for you is a private limited company, because generally investors invest in a private limited company because it's easier to invest there as compared to a limited liability partnership. So, my advice generally to startups who are looking at being there in the long haul and looking at raising funds is please go for a private limited company. Yes, there are compliances, but it's easier to raise funds when you have a private limited. Second thing is, okay, you've started, okay, you've identified that you want to go in for a private limited company. Now, for a private limited company, you would want a founder or a co founder. So there, a lot of people say it's okay, we are two friends or people coming together. Why do we need an agreement? We can just, the AOA, MO is there when we're incorporating the company. So do we really need a legal document? Why do we have to get into all of that? Yes, you do. You need an agreement, especially a founder's agreement, which can be signed up before the company gets incorporated, where you identify what will be the relationship between the co-founders, the roles and responsibilities of the founders, who will bring in what. There are some founders who have been in the industry for a very long time, and they're basically mentors. So what they bring to the table as a founder is their knowledge or their skill. They don't bring in money, but they bring in their ability, their knowledge, their skill, their experience. The other founder could be somebody who's very good in technology. So that person can bring in the technology. And if there is a third person, that person can bring in the capital. So the founders agreement basically identifies who is bringing in what and what are their roles and responsibilities. How much shares will each person own? Will it vest over a period of time, or will it be given, as soon as the company gets incorporated? Are there any exit clauses if a founder wishes to exit? Are there any lock-in periods, such as that the founders cannot leave the company for 2 years, or they cannot transfer their shares? Are there any clauses like that which are binding on the founders? And if they were to sell their shares or sell their shares, what will be the process? Then also some founders do have an important clause, what would be the grounds for removal of a founder. At times people could be very good friends, they could be good colleagues, but after a while they realize that they don't have the same style of working. So what are the grounds? One could be an amicable way of saying that I want to exit and I don't think this is works for me, and then they amicably exit. There could be where one of the founders is not happy with the way the other founders are operating, or the fraudulent practices that person is using, or the way they are going about spending the money, or they are found, they are indulging in certain corrupt or certain other practices which the other founders are not okay with. So some of the founders are very clear, and in the founder agreement itself, they clearly mention the grounds for removal of a founder so that there is no confusion later on. And if a founder commits any of those acts, then he or she can be removed as a founder. Why is it important is because, like I said, it specifies and clarifies each founder's role in the business, provides clarity if and when a founder wants to enter or exit the business, and most importantly, it signals to the investors that you have a serious and well structured business, and that the founders have thought over it and they are clear on how they want to take the company forward and who is responsible for what. So it gives the investors that signal that the founders are serious and they have really thought through everything. Once you have set up your company, you have the co-founders, then the next thing, which a lot of, I'm taking it from a perspective of Bangalore being a tech startup hub. So we're talking from that aspect, but if any of you are not from the tech startup sector, and if you still have certain questions regarding what I'm going to cover, please feel free to ask those questions and I'll be happy to answer. So fine, the company's got incorporated, you have selected your co-founders, everything is fine. And then the most important aspect you need to look at is, what are the IP assets of a company? You need to identify that. You could identify that with the help of a lawyer who could advise you, who could understand the business that you're into and help you identify the various IPs that your company could have. Some examples which I can give you is, suppose trademark. Every company has a company name. They either launch brands or goods or services under their company name, or they adopt a specific brand for their product or services. Now, the brand name, the logo, the slogans, even a domain name work as a trademark. So, simply putting it, trademark should be a mark which should be something which does not describe your products or services. The best trademarks are the ones that are unique or coined words, which means they do not have a meaning. Why? Because they act as a source identifier and offer quality assurance to people that if they buy products or services from this particular brand, it identifies that it will be of good quality. And also helps, for example, if you buy Nike shoes or you buy, you will know that they are of a good quality. For tech startups, the other important aspect is their software. So the source code of a software can be protected as a literary work under copyright law. So a lot of startups do protect their source codes as copyright, which helps them in licensing it in the future. So they create that as an asset for themselves as well. And if there are any manuals on how the software should be used, those can also be protected as literary work. And most important, obviously, is if you have an inventive and innovative product or process which has been developed by you, you can protect it as a patent, provided the invention should have neither been used anywhere in the world nor published in any part of the world. So it should be something absolutely inventive and innovative, and you can protect that as a patent. So, okay, so you've set up your company, you've got your co-founder, you've identified your assets, your IP assets. Next and most important asset for a company, which you all will agree, are the employees of the company. They are the most important assets of a company. So what are the agreements that you need to have with your employees, and what are the compliances that you need to keep in mind when you are starting off? First and foremost is, have strong employment agreements with your employees, which should clearly, so you would have two kinds of employees. One could be who have just passed out and they don't have a prior experience, and the others could be people who have worked with other companies and you're hiring them based on their experience. In either case, some of the important clauses are IP ownership, where you clearly put in your employment agreement that whatever the employee creates during the course of their employment with the company belongs to the company. Some companies go a step forward and they say that an employee is giving in their 100% full-time employment with the company, which means if the employee creates anything while they are in employment of the company, even if they're not using the company property, and even if it is not while they are at office, belongs to the company. So there are extremes. Generally, the law says that where the employee is creating any IP during the course of their employment or engagement with the company, that belongs to the company. So that is one IP ownership. Second, and very important clause also in the IP ownership should clearly say that the employee, when they're creating like a product or a design or a software, they should not use an IP of their employer, previous employer, because that can get the current company into trouble. They can open themselves up for a lawsuit for IP infringement. Second is confidentiality obligations. Again, very clearly telling the employees that you're bound by a confidentiality clause. You cannot disclose any confidential information about the company. Confidential information is something which is non-public information that can be protected as confidential information. Sometimes customer list, customer names, companies databases, how much they pay their vendors, how much they pay their employees, the kind of products they're coming up with, their trade secrets, all of those are confidential information. And another important clause in a confidential agreement is that the employee shall not use any confidential information which they became aware of while working with their previous employers. Then, if you have very senior employment, like key employees of a company, in those cases, non-compete clauses could come in. But if it's a regular employee, non-compete is prevalent mainly only while they are working with the company during the course of their employment with the company. It'll be in very extreme situations, like where they are the CTO or they are key employees of the company, where they get to know about the trade secrets of a company, that the non-compete clauses could be upheld in a court of law. Non-solicitation again can be there, that they should not solicit other employees of the company or reach out to other clients of the company after they leave the employment. These are some of the clauses which are generally there in an employment agreement. Some companies which are IP centric, which have a lot of IP related work, which could be your technology companies which keep creating new technologies, new products, AI based technologies, or they are into creating drones, or things where a lot of invention keeps happening. In those cases, the companies also adopt something known as the IP policy, which clearly identifies the policy of the company in dealing with any inventions or creations by the employees. How will the employees be treated? Will they be seen as co-inventors? Will they have any IP ownership? What if, how will that be rewarded? So those kind of things get covered in an IP policy of a company. Like I said, non-disclosure and confidentiality agreements, IP disclosure agreements, wherein if an employee has created or invented anything during the course of their employment, it is mandatory for them, as per the policy of the company, to disclose to the company what have they created, and ensuring that they have not violated the policies of the company. They've not created a competing product or a competing technology. So that is where some of the technology companies ensure that they also have an IP disclosure agreement, which is part of the IP policy. Then with employees, some companies also have an ESOP pool where they identify how much of the shares will be, how much of it will they keep as an ESOP. It could be between 6 to 10% of the shareholding, and then drafting ESOP policies on how do people become eligible, what are the grounds for granting ESOP policies, all all that gets covered in the ESOP policy. And lastly, you have labor law compliances, where, as per the labor laws, you have to give gratuity to employees, or EPF or PF, and POSH compliances, where if you have 10 or more employees, it is mandatory for you to comply with the POSH law of the country. If not, then that's seen as a violation. So these are some of the things that you need to keep in mind when you're hiring employees. Now, you may have employees, and for tech companies, sometimes they may have people in-house to help them develop the technology, or they may hire consultants, that is, third parties who are not on the payrolls of the company. Now, that is something which is very important, which you need to keep in mind. So, when you're entering into consultant agreements, it could be with respect to technology development, it could be relating to designing. Some freelancers are designing some things, some products for you, they're creating content for you. Wherever you have an IP asset, it is very important that you clearly identify the scope of work, the schedule of payment, delivery, period of contract, everything is mentioned there. So, this could also be for a software development agreement. IP clauses pertaining to license of IP or ownership and confidentiality obligations. It is very crucial that when, if you're getting a technology or a software developed by a third party, you ensure that in your agreements it clearly identifies that it's a work for hire and the third party is creating the software for you, and the IP in the source code belongs to the company and not the software developer. These are important clauses because if you don't have that, then invariably the software developer is the owner of the IP and it stays with them. Non-compete force major clauses: what will happen if there's a force major event like we have been facing in the last 2 years? What would be the consequence of it? How will it be dealt with? Will the parties pay a certain amount? Will there be a reduction in amount? All these things have to be kept in mind, especially when companies are hiring offices or they are taking places on lease. This is an important clause there. Or if you are getting products manufactured by a person, by a manufacturer, or you have vendors, there these clauses do make are very important. And then you have conditions of termination with notice and immediate termination. Why is it important? Third parties are aware of the terms and conditions on which they've been engaged, and it safeguards the IP and confidential information of the company. Sometimes these third party clauses also have exclusivity attached to it, like where you have come up with a design of a product and it's a unique design, and you want a person to manufacture it for you as per the specifications which you have provided them. It is important for you to clearly identify in the agreement that the manufacturer, the person can manufacture and design those products only for you exclusively and not for any other third party. Because if that goes missing, they have the right to manufacture it for anyone else. So these are some important aspects that need to be covered. This will be relevant only for companies which have a website or an app. Like most of us will know, when you sign up, you go, you download an app or you start using a website where you have to log in and give in your details. There is always a terms of use and privacy policy, which a lot of us don't read and just click. But I would advise, especially if it is something where you're giving a lot of your personal information, please go through the terms of use and privacy policy. You need to know what you're agreeing to. So, if you are a person who's offering a website or a mobile app, please ensure your terms of use and privacy policy have been drafted in compliance with the Information Technology Act and the rules thereunder. So, you need to ensure that because it's mandatory, and if you do not comply, then there are consequences and penalties that can be imposed on the company. Terms of use basically
Raddhika,
tell.
can we I'd like to interrupt you to
Yes.
just tell the audience that in case you have any questions,
Yeah.
to just drop it in the comments below. If it's LinkedIn, we'll pick it up separately. And for YouTube and Facebook, we'll be able to see it here. You just have to comment on the comment box. That's it. Thank you. Over
Okay.
to you again.
Thank you. So please start with your, you can, send your questions and we'll be more than happy to answer. So Mansa, if any questions come in while I'm speaking, let me know. I'll be happy to answer those as well. Yeah. Okay. So like I said, terms of use are agreement with end users. In that, you need to let the end users know what is the scope and manner in which they can use the website or the mobile applications, what is permitted, what is not permitted, the representations that you're giving them, the warranties, the disclaimers, like a lot of when you go to a portal and you're connecting buyers and sellers, a lot of those portals will have disclaimers saying that we are only acting as intermediaries, we are connecting you with the buyer, with the sellers, and if anything goes wrong, we are not liable. So you need to be aware of that these are the kind of disclaimers that have been put in there. A lot of people also put in limitation liability. It says that if anything goes wrong, we will give you 500 rupees, nothing more than that. So you even need to be aware of that how are you limiting your liability, or how is the portal limited their liability. Then IP clauses pertaining to license of IP, ownership of content. So these are important clauses where the web or the website or the mobile app, people who own it need to let customers know that whatever content is available on the website or the mobile application belongs to the website and mobile application, the company that's hosting it. And if the users generate content and publish it, then who does that content belong to? Those are also important aspects which need to be covered. And again, the confidentiality obligations. Privacy policy is something which is very important. And as far as a company, if you're a company that is offering the website or mobile application, it is mandatory for you to inform the end users the nature of personal information that you're collecting from them. Whether it's their name, it's their address. Personal information is any information by which you can identify a person. So what is the kind of personal information you're collecting from them? Is there any sensitive personal information that you're collecting, such as their credit card details, their financial details, medical history? These are some of the sensitive personal information. Then the purpose for which the information is being used. The users have a right to know why are you collecting the personal information, and what purpose will it be used for, and when is the information going to be disclosed and to whom. So generally, as a rule, information can be disclosed if it is requested by a court of law, or if it is required to prevent a fraud from happening. That time the company can share the personal, sensitive or personal information of a person with the courts or the authority that is asking for that particular personal information. And generally, companies will also disclose information to their service providers, such as if it is a intermediary where they are helping, it's a marketplace, then they may disclose the information with their service providers, who could be delivery boys who are helping delivering the product. So these are the three aspects that get covered in a privacy policy. So now we've come towards the end of this, and I'll be happy to answer any questions that you have. But quickly, I would just like to share that, when you're looking at, these are some of the aspects that I've identified, which you need to keep in mind as your business is growing. There are many other aspects that you have to keep in mind, but these are some of the points that I thought were very essential for every startup or every business owner to keep in mind. Now, if you're looking at raising funds, okay, this is just a small checklist of legal necessities before you seek funding. And what you need to see is your house in order? Is everything in place? Can you actually ask for funding? Because when you're asking for funding, the investors are investing their money in the company, and they want to ensure that the company and the founders are therein for the long haul. The company has secured its assets. The agreements are watertight. There will not be any litigation against the company. The company, if tomorrow somebody commits a fraud on the company, they have kind of secured their rights, so that they can initiate action against that person and get the money back. Have they ensured that the agreements with their employees and their consultants and third parties are strong, such that there is no issue as to IP ownership or anyone breaching confidentiality clauses? So these are some of the aspects. As far as your IP, intellectual property rights, are concerned, you need to see if your trademark, copyright, patent, or design has been filed. What is the status of that particular application? In whose name has it been filed? Investors will not invest in a company where the IP is owned by the founder. Because what happens if tomorrow the founder leaves the company? They do not want to be going after that founder or trying to give him or her additional money to get the IP from the founder. So they will want that all IP is owned by the company in which they are investing money into. The chances of your funding increase if you have a registered trademark, copyright, and especially if you have a granted patent. Commercialization of IP, again, do you have the right agreements to safeguard and commercialize your IP? If you are licensing your software, are your software licensing agreements clear on the model of licensing, the revenue, the license fee that you are license fee or royalty that you're taking from people, or the subscription fees that you're taking from people? Is all that clear? Agreements with employees, consultants, and third parties. Does it bind them with strong confidentiality clauses and ensure IP ownership by the company so that tomorrow there is no issue when you're looking at funding? We have heard of some unfortunate cases where a software company was very close to receiving funding from one of the biggest venture capitalists in India, but the deal fell through because when the due diligence happened, the lawyers of the other side asked them to show them, to say that they have the source code. And at that time, the software company said, no, but the source code is with the software developer. We don't have the source code. And the deal fell through because they didn't have any agreement to show that the IP in the source code was owned by the company. So these are simple things which make a huge difference at the time of seeking funding. Terms of use and privacy policy. Are you compliant with the Indian laws? If your website or mobile app is catering to people outside of India and especially to the European Union, you need to ensure, and if it's collecting information from there, that you're GDPR compliant. These kind of compliances are extremely important. And then your legal, statutory, labor law compliances, which are there. And the last thing would be permits, licenses, approvals to carry on your business. Do you need a special permit? If you're in the FMCG sector or you're selling food products, you may need a certificate or a license, or a registration with with the FSSAI. If you need, if you are into, then you may need, some companies may need an excise permit, some may need some other approvals. So being clear that you have all the permits and license and approvals that are required for carrying on the business that you're doing. So these are some of the legal necessities and checklists that you can have just to ensure that your house is in order and if you're ready for funding or not. Now, the last and the most last aspect is that fine, you have done your you've done your own due diligence, you're clear that you have complied with most of the aspects that we were talking about in the last slide, and you're ready for funding, and you are talking to investors, and then they share a term sheet with you. So we won't go into the clauses of term sheet because that will be a separate session, but term sheets are very important. Yes, they are non-binding documents, but they are crucial because they summarize the principal terms and conditions on which the incoming shareholders are willing to consider buying shares of the investee company. They are the terms which, if you agree to the term sheet, they get translated into the shareholder agreement, which becomes a binding document. Very rarely will investors agree to change terms at the time of the shareholders agreement if it has already been agreed to in the term sheet, and that leaves a bad taste if the founders are trying to renegotiate once the term sheet has been signed. It's not that you cannot, but it's generally not recommended. That is why when you get a term sheet, ensure that you go to a lawyer who is aware of these kind of laws and can guide you properly. That's very important. So what happens there? There is a certain amount which the founders are looking at, a certain amount of investment, and the founders think, okay, for this investment, the valuation of the company is X, and keeping this in mind, these are the amount of investment I want, and this is the amount of shares that I'm ready to give to the offer to the investors. The same way, the investors are going to value the company, and they have a certain amount in mind that they will invest in your company and the shares they should get. So this is an important aspect on how is the company being valued and how are you looking at what numbers are you looking at and what numbers are the investors looking at. You need to be on the same page, otherwise it can be a deal breaker. Then the other important clauses will be your transfer of shares. Um, how can the shares be transferred? Is there any lock-in period that the investors want to place on the founders or the promoter so that they can't leave? Sometimes the investors put in a lock-in period of 2 years so that the founders are with the company and they don't leave the moment they get funded. Then there are rights of first refusal, right of first offer, where if somebody is selling their shares, then they have the right of first refusal to accept that shares or not. That is generally given to the shareholders. Terms like preemptive rights, drag along, tag along rights, which are given to shareholders if they wish to transfer the shares or buy the shares of the other party. Then there are exit clauses for investors where the investors want for an exit, they want an exit for the money that they've invested in. And that can come in the form of a qualified IPO, it could be a sale to a third party, or they want the company to buy back their shares and pay them the amount. Now, these are some of the important clauses which you need to keep in mind when you're negotiating or signing term sheets. Please do not share term sheets without understanding what the other side is asking you for. Always get an opinion on what you are. You may get the opinion and you may agree to give the investors whatever they're asking for. That's absolutely fine. But at least have knowledge about what you're giving so that tomorrow it does not come as a shock. So these are some of the aspects, and thank you so much. If you have any queries, you can reach out to me at Raddhika at aletheiaalegal.com. My number is here as well. And now I'm happy to answer any questions that may be there.
Radhika, there are a few questions. One is already up, and I think somebody else also here wants to ask you a question.
Okay.
Bhavesh, you can actually post the same question as a comment. We'll receive it here. Before that, there's a question. Posh applies to company with Posh doesn't apply to companies with less than 5 employees, right? What if a company is just founders now and they are looking to build only in another 2 years?
Yeah, so Posh is you a company has to comply with Posh only if they have 10 or more employees. And the definition of employees is very broad under the Posh Act. So it covers people on payroll, it covers freelancers, it covers interns, it covers consultants. So if everybody put together is less than 10, then you don't have to be compliant. As in, then it's not applicable. Yeah. Any other question? I'm not being able to see. I think Bhavesh.
Yeah, I think Bhavesh wants to ask. For the rest of the people here, please feel free to drop in your questions. It is now the QA time. You can drop in your questions and we will pick it up. That's what we'll do. We can still see your screen, Radhika. So
Oh, okay. Sorry.
you can just block that for a
Yeah.
while and then, yes.
Now is it okay?
Yes, yes. Uh,
Okay.
so maybe anything that you would like to cover because we have some time. Obviously, it's just 15 more minutes, but we can just
Okay.
talk about in case something is you think that we need to cover while the questions come in.
See, so the thing is that, some of the important things which I would want to highlight, which I did in the slides, is also that when people are starting off, they often ask that how should I go about it? Does it make sense to invest so much, and how do I go about looking for a co-founder? Um, how should we go about it? So what we've seen and what I've seen in the recent past is that now people are even though they are like signing up with friends and coming together, they are entering into founders agreement because that lays the framework of the company. That is the foundation of the company, where they are coming together, they are actually envisioning how it's going to be, who's going to have what rights and roles and responsibilities. So that becomes very important. And when they are going for raising funds, what is important is that they are on the same page. there are things like, are they ready to dilute their shares? One of them may be ready to dilute, the other one may not be. So we keep hearing stories of one founder leaving and going because they were not, their idea of expansion was not the same. So those are aspects which get covered while they're signing the founders agreement, where they may have, or they may agree that, okay, we are ready to hold so many shares and we will not go below this percentage. So from the beginning, they're clear that, we will not dilute our shares together beyond maybe 51%, whole majority. So these are aspects which are important. Um, the other thing is that, when people are raising funds, even in a friends and family round, that is the first step where the startups will raise funds, right? When they reach out to their friends and family and say, we've started off with something like this, we just need some seed capital, can you help us? And even at that time, yes, there are simple shareholder agreements, but it is important to really think through the clauses that you're putting in, the rights that you're giving to other shareholders. Are they binding the company? Are they going to impact the company in the long run? Also, when we are sometimes negotiating for a promoter, we need to educate them on what rights are good for them, what they should agree for, what they should not agree for. So these are some things which, the promoters or the founders of a company need to keep in mind, that they go, when they're looking at advisors in either aspect, they need to look at, have those advisors, do they have experience in negotiating for promoters, or do they generally negotiate for investors? Because if that is not clear, the startup may not realize that the SHA that they've signed up actually is more in favor of a investor. So they need to do their due diligence at every stage. When you're looking at a founder, you need to do a due diligence. When you're looking at a chartered accountant, you need to do a due diligence. Company secretary, you need to do a due diligence. Legal professional, you have to do a due diligence. You're looking at mentors who will guide you. You need to do your due diligence because you'll follow them. So these are aspects which I will say are important, which need to be kept in mind. When you are coming up with a new idea, do not get super excited and share about it with everybody. Ensure you sign non-disclosure agreements with everyone. Even when we as a law firm are advising people, we always share a non-disclosure agreement with our clients so that they are comfortable that their ideas are safe. So, these are simple things which you need to do. Sign an NDA, get your employment agreements in order, get a consultancy agreement in order. You may feel that it is expenses, but really look at what you're safeguarding at the end. So that's what I would want to share, Mansa. And yeah, these are, I know we can go into a lot of detail, but that'll be too much.
Absolutely. I
Yes.
think there's no more questions, or like I told you, either they are not visible right now because I just checked LinkedIn offline as well. I can't see any; they are not coming up yet. So either we
No
wait for
problem.
that to happen, or I think we just go ahead and end this. Hope I think it's not there. I think it was just Bhavesh. I think that's also cleared. So thank you
Yeah,
so much,
absolutely.
Radhika, for doing this with us. It's always a pleasure
Thank
having you
you.
back. I think almost everyone knows what is your expertise, and they tend to ask you questions around the same thing. So probably everybody is understood. Or if you, the thing is with Radhika, you can reach out to her on LinkedIn as well. She will be able to answer in case whenever she's available. She will try and answer your questions. So anytime you have any query regarding this conversation right now that we had, or anything legal related for your company or your startup, please do reach out to her. She'd be happy to get that sorted for you. And like we have hosted Radhika here, we do these sessions very often. Probably another session coming up next week. We'll talk about a lot of different things for startups, for businesses, for tech companies, as to how things will change for you doing a certain thing, or understanding better from thought leaders. So I hope you people join us for our next session. Thank you again. Thank you, Radhika, for doing this. Take
Thanks,
care, everybody.
Mansa. Pleasure. Thank you.